Hello, my name is Sophie Chilstone and I'm an associate solicitor within the commercial litigation team at Stephensons Solicitors. I work predominantly in the property litigation team dealing with landlord and tenant matters. If you are a landlord and currently don't have a tenancy agreement in place with your tenant, my advice would be that an assured short-hold tenancy agreement is entered into. I also suggest that landlords keep a comprehensive and up-to-date rent statement for the duration of the tenancy. Following the introduction of the Deregulation Act 2015, there are now many rules and obligations that landlords must follow to bring a successful claim for possession. The most common issues that landlords experience is in relation to the service of necessary tenancy documents. A How to Rent guide is a guide published by the government that is for tenants and landlords in the private rented sector to help them understand their rights and responsibilities. A copy of this guide must be provided by landlords to tenants in order to serve a valid Section 21 notice. Most landlords serve this with the initial tenancy agreement. However, following the expiry of the fixed term, should your tenant then be on a statutory periodic tenancy agreement, an updated copy of the How to Rent guide must be served on the tenant if one has been published by the government during the periodic term. These guides are updated frequently, and it is important for landlords to check that they are serving the most up-to-date version of this guide to their tenants. In addition to the How to Rent guide, copies of the property's energy performance certificate and electrical installation condition report must also be served at the start of the tenancy. However, if this has not been served, this must be served before any notice seeking possession. One of the main issues that landlords face is in relation to the gas safety certificates if the property is serviced by gas. Legislation states that landlords only need to retain copies of gas certificates for 2 years. However, we often see that this causes problems if the landlord cannot evidence that the property was gas safe when the tenancy first commenced, if this commenced longer than 2 years ago. It is best practice that landlords retain all gas certificates for the duration that one tenant resides in the property. Not only does the first gas certificate from the outset of the tenancy need to be served, but landlords are also required to carry out annual gas safety inspections. Following each of these inspections, the updated gas certificate needs to be served to the tenant within 28 days. There are also separate rules surrounding tenancy deposits. If a landlord is requesting a tenancy deposit from their tenant, this must be protected in a government deposit protection scheme within 30 days from the receipt of the deposit payment. The amount of deposit that can be taken is capped at 5 weeks' rent. In addition to this, the landlord also needs to provide to the tenant and any other relevant party a copy of the deposit prescribed information also within 30 days. The deposit prescribed information is a separate document, and this contains information relating to the amount of deposit, the parties to the tenancy, the scheme provider's details, and any available information leaflet supplied by the scheme provider. If you fail to comply with the deposit rules, a landlord could be exposed to a claim for breaching these rules from the tenant. If you are a landlord and believe that you may have failed to comply with any of the requirements to provide tenancy documents, our specialist team can provide advice on how to remedy any of these breaches and ensure you are in a position to serve a valid notice seeking possession. This bill was introduced to deliver the government's commitment to bringing a fairer renters market for tenants. The aim of the bill was to abolish no-fault evictions and to reform the landlord's grounds for possession. The Renters Reform Bill was first published in May 2023, however, this is still currently at the second reading stage. The bill is now unlikely to receive royal assent until the spring of 2024 and won't come into force until at least 6 months later, which is estimated to be around October 2024 at the earliest. This is something for landlords to bear in mind, and if a landlord is considering evicting a tenant by relying on the current no-fault Section 21 process, they should consider doing this now, before they are unable to do so once this legislation comes into force. Despite the Renters Reform Bill not coming into force in England until at least 2024, the Renting Home Wales Act 2016 is now in force in Wales. From the 1st of June 2023, landlords in Wales were required to serve a written statement to their tenants, which in effect replaced the original assured short-hold tenancy agreements. The Section 21 and Section 8 routes to possession no longer apply in Wales, and they have been replaced by new routes to possession. The type of notice that needs to be served will depend on what agreement the tenant has in place with the landlord and whether the landlord has complied with the new rules. If you are a landlord in Wales and you are thinking about evicting your tenant, I suggest that you seek legal advice in relation to this to avoid being caught out with the recent overhaul of the eviction process in Wales. Our specialist team can provide advice and assist with the eviction process for landlords with properties in Wales.